Welcome to the second part of the lecture this week. This is Chapter 7, Intentional Torts. Torts is an interesting area of the law. We have both unintentional torts, which we call negligence, and then we have intentional torts, which is what this chapter is actually all about. So exactly what are we going to talk about? Well, in this particular chapter, we'll talk about intent. Obviously, with intentional torts, intent becomes key. We'll also talk about harm to the person. We'll talk about harm to the right of dignity. We'll talk about harm to property, harm to economic interest, and we will also discuss defenses to intentional torts. So, what is an intentional tort? Well, all forms of civil liability are either voluntarily assumed, as by contract, or involuntarily assumed as imposed by law. Tort liability is the second type. So in other words, if you enter into a contract, you voluntarily assume those obligations. So any liability that results out of the breach of that contract, we say was voluntarily assumed because you elected to enter into that contract. You could always choose not to. Then there are certain liabilities that are involuntarily assumed, meaning those are imposed by law. So just by the mere fact that you're a person, that you walk around, that you drive a car, for example, the law then is going to assume civil liability if you operate the car in a negligent manner, right? If you're not careful. So in other words, by driving a car, you assume a duty, so you're expected to drive the car within the legal speed limit, for example. So you have that duty. If you don't do that, then you're breaching that duty. So again, that's something, that's an example of a form of civil liability that's imposed by law. And so tort liability, again, is really those that are imposed by law. It's not related to an obligation that you necessarily assume as part of a contractual or other type of obligation. So the law of tort has three principal objectives. Number one is to compensate people who sustain harm or loss resulting from another's conduct, right? So going back to my car example again. If you're driving the car and you crash into somebody, then the law of tort is intended to compensate that person who sustained an injury, in this case, right, damage to their vehicle or damage to their person because you negligently drove that car or carelessly. Number two is to place the cost of that compensation only on those parties who should bear it. That's very important. So in other words, if you caused the accident, then obviously you're the one that should compensate those people that you hurt. If you were an innocent bystander, let me give you another example. Going back to my car example, let's say that you crashed into somebody, but it wasn't because you were driving over the speed limit or you were being careless in any way, but it was because you stepped on the brakes and the brakes malfunctioned. At that point, really what tort law does is it tries to place the cost of compensating the person only on those parties who should bear it. So in other words, should you be responsible because the brakes didn't work? I guess it depends, right? If you've been maintaining, let's assume it's a brand new car, right? You just bought it, you just drove it off the lot. So really, you shouldn't have any obligation for that accident. Simply it was a product defect, right? The product, the brake, the car didn't function as it should have. So really it's the manufacturer that should bear the cost of compensating that person that was hurt. So that is an example of how the law, in particular torts, tries to place the cost of compensation on the party who really is responsible for it. And also, the other main objective is to prevent future harms and losses. So hopefully through torts, then the law will actually have a deterrent effect. And to a certain extent, it actually does, depending on the field of law that you practice. So let's talk a little bit more about torts. So in general, a tort is committed when, and this 1, 2, 3, and 4 that we see here, these are called elements. If you sue for a tort, and this particular tort would be negligence, the one that's actually outlined here with these 4 steps, you have to, if you're the plaintiff, you have to meet or satisfy or show each of those 4 elements. If you're missing any of those, then you will not prevail. So the first one is that there was a duty owed by one person to another. Again, I'm going to stay to my car example because that's the most basic and the one that most people are familiar with. So if you drive a car, you have a duty to all those around you. Just by the fact that you get into that car and you start driving on the street, the law imposes upon you a duty to everyone else around you. Number 2, the tort is committed if that duty is breached. And again, going back to my example, you have a duty to drive in a careful manner. In other words, you have to obey the speed limit, you have to obey all traffic laws, you have to maintain your vehicle in good working order. If you don't do that, then you have breached that duty. The third step is proximately causes, and 3 and 4 really go together. It proximately causes injury or damage to the owner of a legally protected interest. So in other words, you have to be the cause of damage to another person or injury. By damage, we mean injury as well. So staying with my car example, right? You get into that car, so now you have a duty. You speed down the street, so you breach that duty. You run into somebody and that person gets hurt. Now, you've proximately caused, you are the cause of that person, the damages that that person suffered. And obviously that person suffered damage or injury. Their car is going to need repair, and depending on how bad the accident was, they may end up in the hospital and may lose time off from work and all sorts of other things. So that's in general how tort law works, or what courts are going to look at, whether you met or satisfied all 4 of these elements. So let's talk a little bit about intent, because the chapter is not about negligence. Remember, right? We have 2 different types of tort liability. We have intentional torts and we have unintentional torts, which we call negligence. This particular chapter is about intentional torts. So we need to talk a little bit about intent. So intent, as we use it in tort law, doesn't require a hostile or evil motive, right? So you don't have to desire harm on somebody or want to hurt somebody. Rather, the term denotes either that the actor, the person, desired to cause the consequences of his act, or that he believes that those consequences are substantially certain to result from it. So in other words, it doesn't have to be evil, even though some people may infer an evil motive or a hostile motive, but all you have to do is intend the harm caused, or intend, I guess the harm, consequences is a better word, intend the consequence of your act, or believe that those consequences are likely to result, right? So for example, if I punch you in the face, right? That doesn't necessarily, I mean, I guess it's questionable whether that's hostile, right? I'm assuming that that would be hostile. It's not necessarily an evil motive. I may not hate you, right? It may be a heat of the moment type of thing. Maybe, right? Maybe you said something that really upset me and I lost my temper and I punched you. So it's not really evil, not necessarily hostile, even though that's debatable. But you intended to hit me, right? That is intent, right? You desired to hit me. So that's what we mean by it. So let's talk a little bit about how courts analyze whether the act was intentional or not. So the first question is, does the defendant desire to cause consequences? If the answer is yes, then there's intent. If the answer is no, then there's another question that needs to be asked, and that's, does the defendant believe consequences are substantially certain to result from that act? If the answer is yes, then there's intent. If the answer is no, then there is no intent. So let me give you an example of that. Let's say that you and your friend have a contract for the sale of your house. And so that contract is in place, but I really, really want that house. So I want to do everything in my power to make sure that your friend doesn't buy your house so that I have, or at least I can have an option of buying it. So let's say I go to your friend and I tell your friend that a very, very bad event took place in your house. Let's say that a serial killer killed an entire family inside of your house, and now you're trying to sell it and didn't tell them about it. And let's say that that's not true, that I completely made that up. So for purposes of intent, so continue with my example. Again, just looking at the intent. So did you, or did I guess in my example, right? Did I intend for your friend to break the contract? Whether he does or not really is irrelevant, right? We're just looking at the intent. And the answer to that would be yes. I definitely intended that consequence. And the consequence, again, being your friend breaching the contract. So that's the way we would analyze that. So even if your friend didn't break the contract, right? We could answer the second question there in the affirmative, which would be, does the defendant believe that the consequences are substantially certain to result? So in other words, do I believe that your friend is substantially certain to get out of the contract if he believes that people were murdered in the house that he just entered into a contract to sell? And the answer to that would be yes. So again, that would go to show intent. Let's look at harm to the person. And again, these are intentional torts. What's interesting about these particular intentional torts, these are both torts and crimes. We're only going to look at it from the tort perspective. But battery and assault. So battery, it's intentional infliction of harmful or offensive bodily contact. So in other words, if I punch you in the example that I gave before, right? If I push you, there has to be bodily contact. As long as there's bodily contact, it's a battery. And then the assault is the intentional infliction of apprehension of immediate bodily harm or offensive contact. So the assault would be, for example, if I threaten you, if I say, hey, I'm going to hit you, and I get in your face and I come towards you with a clenched fist, that would be an assault. Battery is when I actually hit you. So that would be the difference between assault and battery. Usually they go hand in hand. You can have an assault without a battery, but if there's a battery, there's usually been an assault as well. So those two go hand in hand. And as I mentioned, those would also be crimes. Battery, assault and battery, you can actually be charged for that criminally as well as a tort. False imprisonment and infliction of emotional distress, two more intentional torts. False imprisonment is the intentional confining of a person against her will. So, for example, if I lock you up in my room and I don't let you out, or lock you in a shed, or whatever the case may be, that's false imprisonment. From a business perspective, this one's a little bit touchy, right? But let's assume that I'm at Walmart and security believes that I stole something. And actually, I didn't. right? But they believe that I did somehow, and they stop me, and they don't want me to leave the store, right? Um, in fact, if they somehow restrain me or don't allow me to leave the store, I may have a false imprisonment claim against Walmart. So businesses have to be very, very careful how they deal with those types of situations, right? If you're not sure whether the person has actually stolen something or not, I think what you need to do is call the police and let the police handle it or deal with it rather than um, dealing with it yourself. Otherwise, not only would you be incurring liability, but the business itself would as well. The next one would be infliction of emotional distress. This is extreme and outrageous conduct intentionally or recklessly causing severe emotional distress. This one's extremely, extremely difficult to prove, extremely difficult to really. I've in 12 years that I've been practicing, I've never seen an infliction of emotional distress. Um, in particular, in Florida, it requires a physical manifestation. So, in other words, it's got to be so extreme and outrageous that it actually physically made you sick. And that has to be measurable somehow. There has to be a doctor that can testify to that. And again, so it's very, very difficult. I have a lot of times people will come to me and say, well, this person, broke their contract and did X, Y, and Z. And then when I really start looking at the damages, I'm like, well, it may be true, but you really don't have any damages. And then immediately, right off the bat, right? Maybe it's because of the movies or TV shows, right off the bat. What about infliction of emotional distress? And it's like, no, that's not how it works. A breach of contract can never rise to that level required for infliction of emotional distress. It's got to be so extreme and outrageous. To give you an example, it has to be to the effect of, and I always give very, very extreme and sometimes gruesome examples, but that's really the only way to make the point with a lot of these. So, infliction of emotional distress would be I kidnap your child and I say, if you don't pay me $100,000, I'm going to shoot your child. And I give, a 2 p.m. deadline. 2 p.m. comes around and you don't pay me the money. So I take the child in front of you and I shoot the child in front. I shoot your own kid in front of you. That would be extreme and outrageous conduct. That would rise to the level of infliction of emotional distress. That's how severe it has to be. Obviously, what I just described is a crime as well, right? But it has to be that severe. So it's in Florida in particular, it's almost impossible. I've never seen an infliction of emotional distress claim. No one's ever made it. It just, the standard's too high. Harm to the right of dignity. In other words, to you as a person, meaning your dignity, your good name. So false communication, so defamation. Within this, we have defamation. Really, there's two different types of defamation. There's libel and there's slander. But as a whole, defamation it's any type of false communication that injures a person's reputation. Libel, if it's written or electronically transmitted. So in other words, an email, a post on Facebook, a tweet, something to that effect. Slander, it's simply if it's spoken. Both of those really are difficult to prove. They're not easy to prove. The problem is not so much the actual defamation. The defamation actually isn't very difficult to prove, right? Somebody either posted something or wrote something or they didn't, right? Slander's a little bit tougher because now you need witnesses. But what's hard to prove really are the damages, right? So, okay, so your reputation has been damaged. How? How do you measure that? How do you quantify that? And there's different standards whether you're a public figure or a private individual. That's really what it boils down to. Let's talk a little bit more about some of the defenses to defamation. Truth is always a defense. So I can always speak the truth, whether you like it or not. Even if I post it, online, I post it on Facebook, I do whatever I want. As long as it's true, then no problem. There's also something called absolute privilege, conditional privilege, and constitutional privilege, which are all defenses to defamation. So there are certain privileges. For example, when you're in court, you could say whatever you want in court, and there's an absolute privilege in court. Constitutional privileges as well. So, for example, Congress, when they're speaking on the floor, they can say whatever they want, as outrageous as it may be. You can't sue them for defamation. That's why you see a lot of these congressmen and congresswomen that just say some of the craziest things, and nobody, a lot of them are just flat out lies, and nobody can really do anything about it because there's that constitutional privilege. And there's a conditional privilege as well. I'll let you read in a little more detail about each of those in the book itself. Invasion of privacy, related a little bit to defamation. But with an invasion of privacy, we have different subcategories. One of those is appropriation. So it's the unauthorized use of a person's identity. So in other words, identity theft would be appropriation, which falls within this invasion of privacy, which is an intentional tort. You could actually sue somebody for that. Intrusion, which is the unreasonable and highly offensive interference with the seclusion of another. So if I want to remain private, right? I put up walls around my house. I want to remain secluded. And you're a peeping Tom. You're sitting there looking over my wall for whatever reason, right? I don't know. You want to take my picture or whatever the case may be. Well, that would be intrusion, right? As soon as I put walls around my house, I expect privacy, and it's unreasonable for you to really try and interfere with that. Probably one of the latest areas where we're running into intrusion are drones. People are using drones, and now you could look over walls, right? It's a lot easier to look over walls. It's a lot easier to film people in their backyards, whereas before you were not able to do that. In Florida, it's interesting. Florida actually has a drone law, and you could actually sue somebody in court for doing that. So if there's a reasonable expectation of privacy, right? So for example, the example that I gave where I have walls around my house. Well, if you can't see me over the wall, then you can't use a drone to otherwise do what you wouldn't be able to do, right? So at that point, you would be liable. Then there's public disclosure of private facts. So that's highly offensive publicity of private information. Again, right, maybe you're having an affair, right? And somebody publishes that and makes that public. If you're not a public figure, again, public figures are held to a higher standard, meaning what would be defamation or what would be public disclosure of private facts for you and me would not be for a public figure. So they're entitled to less privacy than you and I. And that really makes sense, right? Because if you expose yourself to the public, right? If you're on TV, you're in the movies, and if you're profiting from your public image, then you've given up, in essence, your right to privacy to a certain extent, right? It's not absolute, but in essence, you have. So you're going to be held to a lower standard in that case if you're a public figure, whereas you and I would enjoy a lot more privacy rights than a public figure, right? Like a politician, an athlete, actor, and so forth. There's also something called false light. That's highly offensive and false publicity about another. The key fact there being highly offensive and has to be false. So highly offensive and false. So for example, a long time ago, actually it wasn't that long, but in the late 80s where we had the AIDS epidemic and we didn't really understand much about AIDS. So there was a lot of stigma associated with AIDS. And so if you were to have published that, John Doe has AIDS, right? And it wasn't true, that would be highly offensive and false publicity. And so you could sue somebody for false light under that standard. There's also something called misuse of legal procedure. Those are torts that protect an individual from unjustifiable litigation. So, in other words, I really don't have a claim against you, but I just don't like you, and I want you to spend a ton of money, so I sue you and I make something up. That would be the misuse of legal procedure. Again, that's a really tough standard. We don't see that used a lot because, for obvious reasons, right? We don't want to chill people's access to the courts. We want people to sue and not be afraid to sue. So, courts, I mean, in order for you to be found to have misused legal procedure, really your lawsuit has to be completely false or completely without merit. If there's even an argument that you could have made, then usually you're not going to be found liable of misuse of legal procedure, which makes sense. As I mentioned, we do want people to have access to the courts. We want people to not be afraid to use the courts if they need to. So, if just because you didn't have the best claim or the strongest claim, if you would be guilty of misuse of legal procedure on those facts, then it would really chill the process. And we don't want that to happen. So it really has to be more than just a bad argument. It really has to be no argument, that you have no argument and you know it. And you're just trying to harm somebody, trying to make them spend fees. So let's look a little bit. Here's a chart. It's in the book. It's actually pretty good where it puts together everything as far as privacy is concerned. So we have appropriation, we have intrusion, we have public disclosure, we have false light. Then we see publicity, private facts, offensiveness, and falsity. So it kind of helps you to understand how those work, right? So in other words, let's take false light at the very end there, right? So false light has to be a public statement. There has to be publicity. Does it have to be of private facts? No. Does it have to be offensive? Yes. Does it have to be false? Yes. So if that's true, then you would be guilty of false light. Public disclosure, right? Does there have to be publicity? Yes. Of private facts? Yes. Does it have to be offensive? Yes. Does it have to be false? No. Just the fact that you disclose public facts that are highly offensive or private facts that are highly offensive, you would be liable for that. So that's kind of how that chart works. So now let's move on to intentional torts against property or harm to property. Intentional harm to property includes the following torts: trespass to real property, nuisance, trespass to personal property, and conversion. So we'll talk a little bit more about each of those. First of all, though, we need to understand what is real property. And what are we comparing it to? Well, we have two types of property. We have personal property and real property. So probably the best definition, I mean, let's look at the definition here. Real property means land and anything attached to it. So buildings, trees, all of that would be real property. And the best definition of personal property actually is everything that's not real property. Another definition is easy to remember, is that real property are usually those items that are not movable, and personal property are those items that can be easily moved. Now, when we're talking about intentional torts related to real property, the two main ones are trespass and nuisance. Trespass is wrongfully entering on land of another. So, I have my house, I have a fence. You jump the fence, you're now on my property, that's a trespass. Again, the problem that you're going to have with trespass is not so much proving it, right? It's pretty easy. You're either on my property or you're not. The problem is, what are your damages, right? So if I jump over the fence, let's say, let me give you a great example, right? Let's say that I'm playing football with my friend and the football falls into your backyard. So I climb your fence to retrieve my football. Did I trespass? Yeah, I did. Most certainly did. Were you damaged by it? Not really, right? So, you know, I guess you could sue me for that. The court would probably laugh at you. I'm not sure that any attorney would take it. And it wouldn't be very smart on your part to do that, right? If you prevailed, you would probably get what are called nominal damages. And what that means is the court would say, you know what? There's a law. The law says you can't trespass. The person trespassed, so you get $1. That's usually the way that would work. So now let me give you a different scenario though, right? Let's say I throw the football into your backyard. I jump the fence and you have this very, very expensive collector's item vase from 13th century China. And when I pick up my ball, I run into the table and hit the vase and it drops and it breaks and it's worth $1 million. Now that's a different story. Now you could sue me for trespass and I'd be liable for that $1 million in damages. So that's pretty much how that works, right? So nuisance is related to trespass. It's a non-trespassory interference with another's use and enjoyment of land. All right, let's talk a little bit about land. Land is unique. Land is protected uh, by law. It's probably one of the most protected rights under the law are your property rights. So what do we mean by nuisance? Well, when you buy property, you have the right to enjoy. You have the right to use and enjoy your land. So let's say I buy a beautiful house. I build this great pool in my backyard. I love to spend time in my pool. You're my neighbor and you blast music all day long. And so you have the speakers actually facing towards my house so that I get the bulk of the noise all day long. Well, that's non-trespassory, and even that's arguable, right? Because I can make an argument that the sound waves are trespassing on my property. But it's really a non-trespassory, right? There's no person physically entering into my property. But the sound that you're making is interfering with my use and enjoyment of my land. So I would have a claim against you for nuisance. Now, there may be other, right, city codes or county ordinances that are being violated, but strictly looking at it from a nuisance perspective, that's how it works. Well, let's say that you have pigs in your backyard, and let's make it even more dramatic. You have a pig farm, and the smell from the pig farm doesn't allow me to enjoy my property. The smell is so bad that I can't go out in my backyard. Well, that would be a nuisance. Again, right? You're not trespassing onto my property, but the way you're using your property is interfering with my enjoyment of my property. So that's how it works. Nuisance was used a lot a long time ago, prior to the 1970s, in environmental law. It used to be that environmental law was not well developed. It didn't really come into existence till the late 60s. And the very first environmental law called NEPA, National Environmental Protection Act, didn't come into play until, I can't remember the year, but I think it was 1980. So prior to that, really, if there was any type of environmental hazard, the only way to abate it or the only way to address it was through the law of nuisance. And so that's why that was very important. We don't see a lot of nuisance claims nowadays like we used to, right? One of the reasons is because, for example, in the example that I gave, right, in the pig farm, well, you can't have a pig farm in a residential community. We've taken care of that through zoning regulations, right? So by way of zoning, the government then decides where you could have those types of uses. So in other words, they're all going to be mixed together so that your pig farm is not going to bother the agricultural use of your next door neighbor. So that's the way we've addressed those issues. Trespass, when we're talking about personal, so we talked first about real property. So this is now personal property. It's, as I mentioned, everything else, right? Any property other than land. A trespass to personal property is an intentional taking or use of another's personal property. So for example, you have tools laying outside and I need to fix my car. I don't have the tools, so I just take your tools, right? And doesn't mean that I'm going to keep them. I'm going to give them back to you, but still, that's a trespass. I took them and I'm using them and they're yours. They're not mine. So that would be a trespass. Conversion is a little bit different. Conversion is the intentional exercise of control over another's personal property. That means conversion is really the civil equivalent to theft. So that's almost where I'm going to take your property and use it myself. I'm keeping it. I have no intention of giving it back to you. So really, that's probably the main difference between trespass to personal property and conversion. What about harm to economic interest? Economic or pecuniary interest, if you hear the word pecuniary, that means economic. It means the same thing. Economic or pecuniary interest include a person's existing and prospective contractual relations, a person's business reputation, a person's name and likeness, and a person's freedom from deception. So those are the types of intentional torts that we'll find in this area that we call intentional torts against economic interest. So let's talk about each of those a little bit here. Interference with contractual relations. That's intentionally causing one of the parties to a contract not to perform. That's the example that I gave, right? Where you had a contract with your friend to purchase your house, and I went to your friend and I told him, hey, there were murders at that house. You don't want to buy that house, right? House is haunted. House is just terrible. So I'm interfering with that contractual relationship, right? So if I were to do that, you would have a claim for, it's actually called intentional interference with a contractual relationship in Florida. That's actually the name of it. Then there's disparagement. That's publication of false statements about another's property or products, right? So for example, if you're selling a product in the marketplace, let's say it's a beauty product, right? And I publish something, online, or I create an infomercial or something, an ad in a magazine or whatever the case may be, that if people use your product, their hair will fall off. And let's assume that that's false, right? Well, that's disparagement. I'm publishing a false statement about either your property or your products. So at that point, you would have a cause of action against me for disparagement. This one's actually very, very common in business. It's called fraudulent misrepresentation. And that's a false statement made with knowledge of its falsity. That's the key word, intended to induce another to act. So, in other words, I lie to you. Let me give you an example. I have a car. The car has 100,000 miles. It's in great shape though, and it looks relatively new because I've kept it in great shape, but I just used it a lot. So I crack open the odometer and I roll back the miles and I leave it at 10,000 miles. And so I tell you, hey, this car's only got 10,000 miles. It's a great car. And because it's only got 10,000 miles, it's worth $20,000. Whereas if you knew the truth that it had $100,000, the value of the car is actually only $5,000. So that would be a fraudulent misrepresentation, right? It's a false statement about, number one, about the miles that the car has. Number two, about the value of the car, right? Because I played with the miles, I changed the value of that car. made with the knowledge of its falsity. Well, I know it's false, right? I'm the one that cracked open the odometer and changed the miles. And it's intended to induce another to act. In other words, I'm telling you that so you buy my car, so you actually think it's better than it is. So fraudulent misrepresentations, extremely common in business, extremely common in transactions. We see that a lot in real estate in particular. People lie about their property, lie about all sorts of things related to the property. One of the main things regarding property that people lie about is square footage. You could actually obviously measure that yourself or have somebody measure it, but those are the types of things. Related to that is something called negligent misrepresentation. The book doesn't really go into it because these are intentional torts, so I'm not going to spend a lot of time in it, but there's also something called negligent misrepresentation. So here's a chart, and I'm not going to spend a lot of time on it because your book has it, but it actually puts everything together, all the different torts that we talked about, the interests that are protected, right? Those interest of people, uh, dignity interest, property interest, economic interest, and then the torts, right? On the right-hand side, we see the torts that the interests are intended to protect. What about defenses to intentional torts? We already talked about some defenses to defamation in particular, right? Libel and slander, for example, the truth, right? Truth is always a defense. Well, even though the defendant has intentionally invaded the interest of the plaintiff, the defendant will not be liable if such conduct was privileged. A defendant's conduct is privileged if it furthers an interest of such social importance that the law confers immunity from tort liability for the damage the conduct causes to others. So that's just a very convoluted way of saying there are certain circumstances that as a society we recognize to have such value that even though I may be invading on your rights, and even though you may actually suffer damages, we're not going to allow you to sue for that. So an example of that would be, let's say that your house is on fire, right? And I jump, again, I live behind you, right? So I jump into your backyard. Again, you got the very expensive Chinese vase, right? I'm trying to put out the fire. I knock it over. It breaks. At that point, really, you're not going to have a cause of, did I trespass? I sure did. Did I cause you damage? I sure did. But you're unlikely to be able to sue me for trespass because, again, from a social importance perspective, the law is going to grant me immunity, right? We want people to help out their neighbors. The fact that you had a very expensive vase there, too bad, so sad, right? You shouldn't have had it there. Or maybe you should have insurance to protect it. But we want people to help other people out, right? That's where those Good Samaritan laws that somebody mentioned in class the other day come in, right? We want people to help other people out. We don't want you to be punished for helping somebody out. So you're not going to be liable for trespass, right? That's also going to be true if you're a police officer, if you're a firefighter, if you're a paramedic, right? You could go onto people's property. Are you trespassing? Of course you are, right? Are you causing damage? Maybe, right? You may or you may not. But in either case, the law confers immunity from tort liability in that situation. And again, get into the Good Samaritan law. The way that works, right? Remember, I talked in class that you do not have a duty to help somebody out. You could actually watch somebody die and you're not liable for that. So Good Samaritan laws are intended to protect Good Samaritans, right? It used to be, it happened for a while that, let's say you got into an accident. Most people morally, just out of their own nature, help. I mean, it's just the way most of us are wired. You don't just walk away. You help. And what was happening is a lot of times because some of the people that tried to help didn't have any medical training, depending on the type of injury that the person had, there are situations where bystanders that were actually trying to help made the injury worse, right? So for example, if somebody has a really bad neck injury or back injury, many times you don't want to move them. The worst thing you can do is move them. If you move them, right, and that's why when the paramedics come, they put them on those long wooden boards, right, to keep their back straight and so forth, and put them in the neck brace and secure them, because you can cause nerve damage. You can actually cause permanent paralysis or permanent damage. And that happened, unfortunately, in more than one circumstance. And what ended up happening is that then these people that were involved in the accidents actually sued the people that helped them and aggravated or made their injury worse. And so the problem with that, right, is if you win that lawsuit and you have to pay, then what's going to happen the next time anybody sees an accident? Well, they're not going to want to help, right? Because they're like, well, what if I cause injury? What if I get sued? I'm not going to help. I'm just going to walk away. And as a society, we don't want that. And so that's why these Good Samaritan laws came out. And in essence, what those Good Samaritan laws say, that if you started helping somebody out, and even though you don't have any training, if you hurt them and obviously they didn't intend to, they can't sue you for any damage that you may cause. So that's an example of one of these defenses that we're talking about. Well, here's another one. Consent. A person may not recover for injury to which he willingly and knowingly consents. So in other words, right, I'm sitting in my backyard. I invite you to come over. You come over. We get into a fight. I call the police and I say, hey, this guy trespassed. Well, no, not really, right? You gave me consent to be there. Now, that consent can be revoked, right? So, for example, if you tell me leave and I don't leave, that's different, right? At that point, I do become a trespasser. But if you don't tell me to leave and you're just mad at me and you call the cops because you're mad at me, that's not trespassing, right? You gave me consent to be there. Same thing if, the tool example, right? Your tools are outside. I go and I ask you, hey, can I use your tools? You say yes. I use the tools. Later, you try and sue me for trespass to personal property. Wait a second. You gave me consent. You let me do this, right? You let me take your tools. So that's what that means. Self-defense. A person may take appropriate action to prevent harm to himself where time does not allow resort to the law. So in other words, right, somebody comes and hits you, right, or pushes you. And at that point, really, you got to defend yourself, right? So, somebody pushes you and you punch them, and then they try and sue you for assault and battery. It's like, wait a second, it was self-defense, right? The guy pushed me first. So those are the types of situations where self-defense would apply. Remember though, right, it has to be equal force, right? I'm giving here an example of a fist fight, but if the person pushes you, you can't pull out a knife and stab them, or you can't pull out a gun and shoot them, right? Those are the types of things that you would not be allowed to do in a self-defense perspective. So it has to be equal force, right? It has to be equal force. Unless you fear for your life, right? I mean, a situation where a person may be able to use a gun when the other person is unarmed, right? Let's say I'm 6'7", 300 pounds, pure muscle, and I push you to the ground, and you're a 5'2" woman, and you're deathly afraid of me. You think that I'm just gonna hit you, and that if I land one punch, I could cause some serious damage, and you're seriously afraid. And let's say next to you, you have your 2-month-old baby in a stroller. Well, at that point, you're justified in taking out the gun from your purse and shooting the person. So even though in that situation, it's not equal force, meaning the person didn't pull out a gun, but based on the difference in size and based on the difference in the situation where the person, right, the woman had a baby, the woman feared for her safety, feared for the safety of the baby. Again, just based on this size and strength difference, then at that point it would be justified to shoot the person. And I'm using the word loosely, right? Because you would still be arrested, you would still have to go through the legal process. Whether the prosecutor decided to press charges or not would be a whole different story. They may or may not, but if they do, you would have to defend yourself and you would have to actually raise self-defense as a defense. So it would certainly not be a pleasant experience one way or another. And again, that's from a criminal perspective. From a civil perspective, you could actually be sued. So, that's interesting. A lot of crimes, or most crimes, are intentional torts as well. So you may end up going to jail and you may also be sued. Good example of this is O.J. Simpson, right? O.J. Simpson went through a very, very famous trial. We'll actually see clips from that trial in class because there's a lot of it was actually a very good trial, very good lawyers involved. Um, so we'll look at different aspects of that, but he prevailed at the criminal trial. Remember, right? I always like to point this out. He was found not guilty. Doesn't mean he was innocent. Not guilty does not equal innocent. Not guilty simply means that the state could not establish or satisfy its burden of proof, which in a criminal perspective is beyond a reasonable doubt. So in other words, the jurors found that there was reasonable doubt, and that's all they need to find, which is only about 1%. That's all they really need to find, right? Beyond the reasonable doubt means almost 100%. So again, don't confuse that. Not guilty is not innocent. So going back to O.J. Simpson, he was found to be not guilty in his criminal trial, but he was also involved in a civil trial for wrongful death. And in the civil trial, he lost. The civil trial, the standard is a lot lower. The civil standard is called preponderance of the evidence. And all that really means is that it's more likely than not. So it's about 50% plus 1. So it's a lot easier to prove. And so O.J. Simpson was found guilty in that civil trial, and I think, I don't know exactly, I think it was like a $30 million judgment against him. So those keep that in mind, right? A lot of criminal acts are also intentional torts. And so you will likely face criminal action, and you may face also a lawsuit based on the intentional tort sometime thereafter. Any questions, please let me know. Please email me. But this is the closes really our next week here. Please make sure that you look at the agenda and that you do the problems for these two chapters, chapter 6 and 7, the problems that are assigned. Make sure you read the cases, and hopefully, I know last time we didn't have a chance really to get into the cases. Hopefully we'll have an opportunity to do that in the other classes. Take care, and we'll see you next time.